In a history-making move last week, the New York District Attorney's Office filed criminal charges of falsifying business records against former President Donald Trump. 3 other legal investigations against Trump are underway, and there's been some criticism by analysts that this case, the New York case, might be the weakest. For analysis, here's Hamline law professor David Schultz. Well, joining us now is Professor Schultz. Thank you so much for coming on.
My pleasure. Thank you very much.
As I said before the show when we were chatting, I just really have wondered, looking at all of the coverage of Donald Trump's indictment and arrest, why there's been so much criticism by legal analysts of the actual charges themselves and the way it's laid out. What's going on here?
Okay. Now, first, we have to sort of sort through the fact that there's probably some ideology coming through in terms of some of the legal analysts.
True.
And so let's bracket that off to the side. But in addition to that, for a lot of legal analysts who are not experts in New York law, they don't perhaps understand the nuances of New York fraud law in terms of how it applies. That's a second possibility. A third is the fact, and I saw the same thing, even leading up to the indictment, a lot of people saying these are not good charges or this is not a good case without actually having examined the evidence. And I say all of that because we have to put the law, the facts, all the evidence together to really assess the case. And we're not going to know now for several more months until we go through discovery, we go through pre-trial disclosures, really what the full scope of the case is. So that's sort of kind of a preliminary statement here, an awful lot of prejudgment one way or the other regarding the merits of the case.
Okay. I've seen a number of analysts say that the DA is trying to shoehorn these charges into felony charges. Do you agree with that, or is there anything to that?
There's a sense in which it's true, but also let's think about, again, the New York State fraud law and what the fraud law that Donald Trump is being charged with violations for 34 times says essentially that if you commit business fraud, normally it's a misdemeanor. But if you commit business fraud for the purposes of concealing another crime, then it can be shoehorned or ratcheted up to a felony level offense. And what the prosecutor in New York is trying to argue is a couple of different theories. One is that the primary violation of what we call in the law the predicate violation is either a violation of federal campaign finance law or perhaps a violation of New York State campaign law. And therefore, because Trump was trying to conceal a different crime through his business, that's the way they're ratcheting it up from normal misdemeanor fraud up to felony fraud. Again, I have to somewhat defer to the prosecutor who said at this point that we do this all the time in many other areas of fraud in Manhattan and New York. Assuming that's the case, and I think it actually is true here, the real question becomes, and where the novelty is a campaign violation a sufficient prior bad act to then ratchet it up to a fraud?
And that's what this case is about. Well, it'll be interesting to follow. David Schultz, thank you so much for coming on.
My pleasure. Thank you, Esme.